members have taken advantage of that?
Off the top of my head, I don't know, but I'm sure I can look into asking for an extract.
Yes, I think I think that the board should know how many fee waivers were given for that, governor's order. I think that would be helpful information the board should know.
Yeah, I think that's a great point. And we can add that to our CME audit to see if there's a pattern. Like Dr. Patel has mentioned, just to see what's going on with those numbers. I would like to see that 10% even less, but I'm not sure if that's being affected by COVID / the recent fires and so forth. But for the board and for our board, the smaller that number will be better. Thank you.
And also it'll affect our income. If we have a lot, LA is our biggest concentration of podiatrists in the state. I don't know for a fact how much from those particular zip codes. However, if 10% of our licensees have a waiver on their license fees, that may affect our budget. So I do think that we need to know the impact of how many licensees are taking advantage of that fee waiver and how much of a impact that has on our income or in our revenue.
On that point, do we know if this governor is subsidizing the board for that waiver?
So they just have, they still have to pay. They just have a year extra to make that payment. So they can go on and renew and pay $0 today, but by next year they would have to make that payment.
I just want to be clear about my comment earlier regarding the audit and finding out who hasn't met the CME criteria. It's not to find a way to quote unquote punish our licensees. We're here for this public service. I just want to make sure that the CME criteria and our licensees are not seeing any miscommunication on seeking CMEs, or they might be looking into CMEs that may not qualify for our renewals, or if they have any misunderstandings in seeking proper CMEs. I have this firm belief that they are all looking for the right and correct CMEs every renewal year. I just want to make sure the communication is properly done to them, and then they have no sacrifices and shortcomings in reaching out to CMEs. That's all.
We do have an initial licensing packet that goes out to each DPM once they're licensed that has fact sheets on CMEs and to reach out to us if they have any additional questions. There's also a section on the website where it has the fact sheet as well for CMEs. Just wanted to mention.
Oh, great. Thank you. I think that's going to be important since this is all a new process. I'm wondering if there'll be room to add that fact sheet in our next newsletter as well. That'll be great as a reminder to all of our licensees. Thank you so much. Should I take public comment after? Yeah. All right. Item B, enforcement program. Mr. Hill, not here today. Okay. Could we have the presentation for it? Yeah. Any public comment on section A for licensing program? Okay, thank you. We'll move on to section B, enforcement program.
So it would be Dr. Glazer filling in for Darlene.
Oh, Dr. Glazer, could you head the presentation?
Gladly. For the enforcement program, I'll kindly ask Ms. Bethany to take over the portion of this and educate us thoroughly. Thank you.
Good morning. The enforcement report today, it covers 2 quarters of fiscal year 24-25, July 1st, 2024 through December 31st, 2024. Okay. No, it's finished. I pushed it, but it didn't turn on. Oh, okay. Because I'm reporting 2 quarters together, I'm just going to kind of skim over the highlights and then report on attachment D, which has all of the totals for both quarters. I did want to mention some issues with the investigation data at this time. I was noticing that not all of the data added up appropriately, so I've put a ticket in with DCA to get that fixed. We're still working on getting that corrected data, so hopefully by the next report, I will have corrected data for quarter 1. for the investigations. But I have reported it as the report currently states the data. The other issue with investigation data is that we did not have a assigned analyst at the medical board for desk investigations for about 6 months. So this did produce a bit of a backlog. Investigations were moving, but moving more slowly while they worked to get some vacancies filled in that unit. So there was 30 pending desk investigations in July of 2024, and that increased to 71 by December. They've now hired a full-time individual, and these complaints are moving again. So we should see that number dropping in future reports. And then I'm going to focus on attachment D, which is a summary of both quarters together. So we saw a total of 75 complaints received those first 2 quarters, an increase of about 4% over the prior fiscal year 2 quarters. Total investigations assigned increased 7%, with 78 investigations assigned during the first 2 quarters. And the average days to complete desk and field investigations was 325 days, which is quite an increase over the prior year, where investigations averaged 130 days. This is because of the slowdown of desk investigations. A few months added to each desk investigation is going to raise that overall average of both desk and field investigations together by quite a bit. Again, we should see this number start to come down now that those investigations are moving again. We had 8 discipline cases initiated through the Attorney General's office, which was an increase of 167% over 3 cases initiated the first 2 quarters of the prior year. And cases took an average of 1,066 days to complete, an 8% decrease over the prior year of 1,155 days. We had 5 final disciplinary orders issued compared to 4 the prior year, and 3 citations were issued. The codes violated are shown on page 3 of attachment D. And moving back to attachment C really quickly, we had 1 successful completion of probation. And at the end of the second quarter, we had 7 active licensees on probationary status. We are closing more cases with a public letter of reprimand with conditions versus probation than in the past. So that's why that number is pretty small. And now attachment E is the Attorney General case aging data. So this includes information that through January 23rd, 2025. We do have several petitions lined up that are going to be heard at a hearing. We don't have all of the dates for that at this time, but we're looking probably in the next fiscal year of multiple hearings taking place. I did want to mention that we do not receive cost recovery from these hearings, so these cases could end up being an additional cost burden on the board. It's a good thing we have our fee increase moving through, but we'll see soon just how hard hit we are by these hearings. And we have about 16 active cases pending completion with the AG at this time. Do we have any questions on the stats?
Dr. Michaelin.
So is there an increase in the number of hearings than usual? Is that what you're saying?
I'm seeing now that I think COVID has passed, we're having more people that are looking to reinstate their licenses or petition for a reduction in discipline if they're on probation to maybe get off early. And I am seeing more than usual coming through right now. We, in the past, had 0 to 2 probably per year. We're looking at 4 or 5 hearings coming up probably this year alone.
So these hearings are not just new disciplinary actions. These are people who already have an active disciplinary action and they're asking for mitigation in some way after they've already received their discipline.
Yes, so the majority of the cases, they've lost their license. Their license has been revoked and they're looking to reinstate their license. So they have to go through the legal process by having the hearing with an ALJ, and then it goes before the board to vote on. But it's not going to be considered a new complaint.
So they've already had their license revoked and they're trying to get it back.
Yes.
Okay. Thank you for that.
Any further questions on the stats before I move
Just on that same point, because that is a cost to the board, is there any plans to recoup that cost from the providers that are requesting an adjustment to their probation period?
Unfortunately, at this time, there is not a way to recover those costs. They have to pay any costs that maybe were ordered at the time of their revocation. So that complaint that led to the revocation, any investigation and AG costs incurred, they'll have to pay that before they can be reinstated. So we'll get money back from that. But for the hearing itself, there is no path towards cost recovery at this time. And I don't know if that's something we can do.
Is it a,
I was just going to ask, do you think the cost recovery, well, let me ask this, if these secondary trials or hearings to get their license back, are they less costly than the original?
It should be less costly because there's not going to be as much investigation time incurred. We're not investigating a new case. But it just depends. The hearing can last, a half a day, it could go all week. So those costs can add up quickly. A recent hearing that lasted a full week cost us over $50,000 just in the ALJ costs. So it's dependent case by case. But yes, potentially it could be very costly for the board.
I was going to ask you if you had any historical data on cost. I'm almost sad that I did. So thank you.
So you, Dr. McAloon.
so, are there opportunities, they're not in place currently because you can't do what you haven't said you're gonna do, but are there opportunities, for example, I don't know what other boards do, but can you require that you've paid off what your disciplinary fees before you can request a hearing for reinstatement? Or can you have a fee to proceed with the request of a reinstatement? Are these opportunities that we can engender revenue?
So these are things we're looking into. And in fact, I just noticed medical board put something on their board meeting agenda recently about having a fee to apply for the petition process. It wouldn't get all the costs back, but it would be a little bit of something. So we're talking about that now in the office.
Mr. President, could we just have that added as an agenda item for a future meeting to learn more about those opportunities to generate revenue in relation to the reinstatement hearing process?
Absolutely. I think that's a great point. Thank you, Dr. McAloon. We've been talking about, and this is just a comment and discussion as well, about our aging and the cost that it's incurring for enforcement. And I remember many board meetings as we looked into our aging data, especially our case number 1 and case number 2 in attachment E. We keep seeing those dates. So I think it'll be interesting to follow the lead with our medical board to see if any temporary or preemptive fees can be accrued prior to petitioning any extension or next phase in the enforcement. I think that's a great idea. Thank you.
And just provide the board a little bit of background. So right now, the way cost recovery works is they're done pursuant to statute. The board itself has its own individual statute that we follow, which authorizes cost recovery and, granted, I'm speaking this off the top of my head, disciplinary actions prior to the case. Bethany, does that sound right to you?
Up until hearing.
Up until hearing, thank you. And stuff. Part of that is there's case law that says that the board basically under due process, since we're a government body, we have to give people due process, and charging for the board's time as the adjudicator would violate due process. We are currently looking into other possibilities right now, how that might play out, say in a post-disciplinary hearing, like a petition for reinstatement. We're paying attention to what happens with medical boards things, seeing if there's any litigation that comes out of that, how that affects the board processes too. So this might be an ongoing conversation with the board too.
Okay, thank you for the update.
Yes, we should follow that along with that, please.
Any other questions, comments on section B?
I
like
was
to-
just going to finish up really quickly. There's the DCA performance measures. Just you can look up our performance measures online historically. And then the probation program update for cost recovery, we recovered $80,571.44 in cost recovery, $13,460.45 in probation monitoring, and $5,000 in citation payments for a total of $99,031.89 for the first 2 quarters. And this is pretty on track with the prior fiscal year, where we recovered a total of $220,000 for the entire year. So looks like we're on track for cost recovery. And that concludes my report, unless there are additional questions at this time.
Thank you. Just a
you.
quick update on that comment and idea from Dr. McAloon. If we're able to, and our legal counsel about our statutes and how we do cost recovery, if there's an opportunity for us to find out what the potential cost recovery would be if the statutes were changed in order to obtain fees ahead of time or to the point to where they are before they are reinstated, what those figures might be. Financially, things are really difficult for the board and in general. So I think those figures will be interesting to see and for discussion for the board if it's attainable.
Right. At this time, before they can get reinstated or reactivate their license, they do have to pay any prior fees from prior cases, but the hearing fees would not be included. So that is what we're looking at now, the hearing costs.
That'll be great. Thank you. Thank you for the presentation. Any questions, comments? And I'd like to apologize, Dr. Glazier. I didn't know he was heading that committee, so
I think
my
actually,
apologies.
I think you're on it now. So he was at the committee meeting, but then the new list came out and now you're on the committee. So
That is correct. And I forgot that too. So it's
team effort, so.
welcome to the board. Thank you, everybody. I'd like to open it up to public comment. All right, thank you. Let's move on to section C, which I chair. Kathleen, could you help us with the presentation for section C?
Thank you, Dr. Lee. This is Kathleen Cooper. I'm going to give the legislative program report. So we have 3 bills that are included in this report. First one has to do with 2 existing statutes. It's not a bill yet, and it may not be a bill. It may be something that is going to be looked at through our sunset. But there's 2 sections of the existing business and professions report, and I suggest we all go to attachment A to see the actual language. So last year, there was some legislation that required the word doctor. Some people can and can't use it. It was passed and it affected us. Well, this is what we're asking in our sunset, that we put the word in red, podiatric surgeon, among all those other titles, podiatrist, doctor of podiatric medicine, foot specialist, podiatric doctor, many different DPM, but we would like to add podiatric surgeon because it's very important to our DPMs that they have the word surgeon in there. And it seems to be a well-supported title. So any comments on changing 2474 to add the word podiatric surgeon would be welcome at this time. We still have some documents that we are finalizing in relation to the sunset report, and that's where we would be asking for this, is in the sunset review process to be able to put this in. So any comments you have or any
Yeah, no,
ideas you
I
have to be
don't
helpful.
have comments because this is an action item. I need a board motion for approval or so I can move forward and drop this into the sunset bill. There's going to be 2 action items here, 2474 and then 2488. So
Do
we can
you
move those.
need us to take action and have a motion per item?
Per item, yes.
Okay.
I'd like to make a motion for, is it a regulation or statute?
Statute.
Statute 2474, that we submit adding the term podiatric surgeon to one of the public descriptions of who we are and what we do, along with the others already listed.
Do we have a second?
I second that. Dr. Patel.
Dr. McClellan, could I just make sure I grabbed that motion correctly?
Sure, and I'm happy to have any wordsmithing that it makes it more clear.
Yeah,
what I
yeah.
was
Do you
trying
want
to
to
say.
restate it? So I didn't quite, wasn't quite typing fast enough.
What do you have so far? Because I've already forgot what I said. My intent.
Let's see. We can write something up together.
Exactly.
quickly. Why don't we just do that? So, I guess this also would involve Brian. Brian, what would you like for the motion? What are you looking forward to see?
I would just say that the board motion to add the language of podiatric surgeon to BPC code section 2474.
Thank you. That is the intent of my motion. Yes, thank you.
That
I like to use 20 words when you only need 5.
It's 2474?
Yes.
2474. And we have a second from Dr.
I second
Patel.
that, yeah.
I'd also like to make a motion as well for. My apologies.
No.
Got excited.
All right, so let's finish with 2474. We have a motion, we have a second. I'd like to open it up for public comments.
No.
Thank you. Could we take a vote? Kathleen,
Yes. Dr. Lee,
accept?
Dr. Glazier,
Accept.
Dr. Patel,
Accept.
Dr. McAloon.
Accept.
The motion passes.
Thank you very much.
Okay. So Brian will be able to take that back to sunset. The second part of this is exactly the same. It's 2488. And in this section, we are trying to get rid of the requirement that part 3 is part of how you can transfer into the state from another state. It's not reciprocity per se, but it is a requirement. You fill everything else out like you do right now, but not the part 3. So are there any comments on this change to section Business and Professions Code 2488, which would strike the entire subsection B?
Yes, I like to speak on this issue with the rest of the board. I'm in favor of this. I have, I think one of our duties is to minimize obstacles to the practice of podiatric medicine in California for those who are have the training, education, experience to do so. There have been, I'm aware of at least 2 situations where a well-experienced podiatrist was looking to come to California. They're board certified. They have all their license, other rest of the application in good order, but they've been practicing for 20 years, so they haven't taken part 3 in the last 10 years. And so I think it is onerous. We took it off. The other thing, it's no longer compatible with our license renewal because we removed the A through G requirements previously on our license renewal. So there was a time and a place when this was appropriate because the people in California were held to that standard and people coming in were held to that standard. Now that we removed that standard from our license renewal, I believe that it should be removed for not new podiatrists, old podiatrists who want to move to California and practice.
Dr. Patel?
Thank you, Carolyn. Yeah, I think it makes sense that we match what we've done for those that are currently in the state, for those that are coming into the state.
Any other comments, questions?
I'd like to make a motion to strike paragraph B from the statute number 2488.
Do we have a second?
I second the motion.
Dr. Patel, second. I'd like to open it up for public comments. Any public comments? Thank you. Would like to take a vote. Kathleen, could you help us with the board vote?
Absolutely. Dr. Lee,
Accept?
Dr. Glazier,
Accept.
Dr. Patel,
Accept.
Dr. McAloon.
Accept.
Motion passes.
Thank you.
The next bill on the report is our sunset bill. So if we are renewed, Sunrisen, I guess, we will be with the physician's assistants and podiatrists in this bill, and we'll go for another 4 years. This just covers the whole oversight process. I do not believe you have to make a motion on this. It's just for our knowledge, that's the bill that will get you going for another 4 years.
Right, it's just an FYI, this is our sunset bill. It is AB 1501. Just so you can follow it, we'll track it. So it's just an FYI, that is our sunset bill.
Okay, so that's a non-action item. Thank you.
But I have a question. Is that an
Yes.
all or none, meaning they accept both the physician assistants and the podiatric medical board review, or they sunset both because we're linked in one bill?
No, it's
Okay.
just
It
it's
can
just
be,
a placeholder.
okay, thank you. Okay, fair enough. That was my question.
Okay. So we'll keep you posted on that.
Thank you.
And the last one is just an acknowledgement of a Special Olympics that we would like podiatrists in the state to know that they are welcome to participate in volunteering in a statewide, will be happening this year in 2025. And maybe if you get involved, you'll be in the future too, but it's just a volunteer opportunity. So Special Olympics will be happening here this year. The bill did already pass. And we just wanted people to know that. Yes, Karen.
I am aware that there are podiatrists throughout the state who have a commitment to volunteering with the Special Olympics, and that's an important part of, they do it I know many podiatrists who participate yearly on this. If there is a way to promote our licensees who do participate, perhaps something in our newsletter, thank you.
Yeah.
Our newsletter, maybe interviewing someone or telling about their
Very nice, yeah.
experience. I think to link in with that in our public relations committee perhaps can reach out. And if you need some names of maybe people to give a call, I'm sure board members would be happy to share with you the people that we know that are doing Special Olympics.
It would be so nice to have a nice photo and a featured person that's doing it. So we'll take this offline and see what we can do.
Fantastic, thank you.
Okay, thank you. That concludes the legislative section of my report. Go on to regulatory.
Thank you.
Yeah, we still have that one item, Kathy. Ancillary.
Oh, excuse me, yes. So the board is going to discuss to take actions on the ancillary status of DPMs. I believe this has to do with the fact that DOs, MDs are considered physicians and surgeons, and we're in a middle spot there where we're the surgeon, but we're not considered the physician. And therefore, in certain, maybe it's just the computer systems or whatever, but they get thrown, DPMs get thrown into a non-medical, non-surgical category. And there's many issues that full spectrum of scope, as well as reimbursement fees under the benefits plans, et cetera. So this is just so we can start addressing this issue of how their DPMs are categorized. Does anyone have any comment on this issue?
I just want to remind the boards as we get started with this discussion that we are tasked with public protection. So today, I know we all wear many hats. So today it's the public protection hat as we're talking about this issue.
Dr. McAloon.
Yes, thank you for reminding us of our duty, and protecting the public includes access of care to the right provider at the right time. And it's my opinion is that's how this falls under our duty, to protect the public, because if the public does not have access to foot and ankle care, they are at their health is at a disadvantage. So that's my feeling about how this is protecting the public by dealing with ancillary status. And to Kathleen's point, there are different ways that physicians and surgeons are categorized. The ancillary status is in certain different places. For example, the Medicare statute, we are R3 and not R1 in that statute, which is part of what looks like a physician type of provider, but not exactly. And I think that addressing that ancillary status or allied health or any other phrasing that is not physician and surgeon is not an accurate description of the education, training, and experience that podiatric physicians and surgeons have and the care they provide. We provide the same exact procedure codes as any other surgeon. I think one of the, here in California, but hopefully other places, same pay for same job. That equal pay, there it is, equal pay for equal work. I was trying to remember. Is I think a value and a principle that is, should be held up in here in California as well. And those are some of my thoughts on the discussion on this status, the statement for the podiatrists here in California.
Dr. Glazer?
Well said, Dr. Macklin. I agree. This is a public concern and a public well-being concern. We have many healthcare deserts for podiatric care in California. And if we raise the pay levels to, as you said, same work, same pay, or equal pay, I think some of those deserts may go away. And that's how we can serve the public today, by making this so.
Yeah, I would just,
Dr. Patel?
thank you. Thank you. Great comments from my colleagues. I'm fully supportive of this discussion and moving towards this. I have a question about other ancillary providers or healthcare providers that fall into this category. Are there other providers that also have similar issues and have had to make this move?
That I'm not aware of at this time. I didn't take that deep of a dive into other practices.
Yeah, my question is, why does this category exist? Is really kind of why. Like, do we know why this category exists?
I don't know that it's a category as much as a descriptor that some other health care providers who are not designated or physicians and surgeons in different places might be lumped together as they provide health care, but not necessarily our physicians and surgeons. As we all know here, we are held, doctors of podiatrics and are held to the same standards as any other physician and surgeon in their practice of medicine. We know that our education and training is held to the same standard as medical doctors and doctors of osteopathy, 4 years of podiatric medical school, 3 years of medicine and surgical residency. So there's no other category of provider that in allied health that has that same scope of training, education, and independent practice. So I think this is specifically written for only for the doctors of podiatric medicine and not including any other provider type that may or may not be in that designated the same, is my opinion on the read and purpose of this.
Brian, we are discussing this as an FYI for the board, correct?
Well, we could do.
There's no action item.
We could take action on this, and then this was a topic that was brought up by the Assembly Chair, Berman. So it would be nice to take some action from the board. This could be a possible drop to our sunset bill if we board and have the committees evaluate more of it. Obviously get the support from the California Podiatric Medical Association as well. My suggestion is that we move forward. We just take it from there. The meeting is not going to be until June. Trying to take action on this. So taking action on this board vote would probably be at this point. Just comb things out.
Per Mr. Naslin's comments, I did tell the chair of the BMP committee that we would be taking this under discussion today and would report back to him on the board's discussions on this item. So we do have that obligation to let them to report back to the joint BMP committee about our discussion on this topic, because I told them we would.
Okay, that's fantastic. That's I welcome that, but we need
Now,
specific topics though,
Yeah,
specific.
before we get into that deeper dive of maybe a motion, I would suggest opening up for public comment because we do have a representative from CPMA that would probably like to speak about this and get their perspective.
That's great. Do we have a representative from CPMA?
Thank you, Mr. President. Ryan Spencer with the California Podiatric Medical Association.
Thank you. Welcome.
Thank you. I really don't have much more to add based on the comments from Dr. McAloon, Dr. Glazer, and Dr. Patel, and your question as well, Dr. Lee. I think with the one question you did have, I'll add to that. I mean, ancillary providers really are there to support, help with the diagnosis. Physical therapists are ancillary providers, for example. Radiologic technicians are ancillary providers. In the clinical setting, there's no question that you are equivalent to a physician in what you do. You practice independently. You have your own unit. You could be a chief of medical staff. When it's not really a question of the clinical setting, it's a question of the administrative use of this word. And oftentimes you get lumped in with the other ancillary providers. And that was what we heard from many podiatrists in the state when it comes to how they're characterized in a facility, how they're treated through payment processes with their plans. Often they can work it through, but it is unnecessary burden. And the whole question about patient safety is exactly what Dr. Glazer addressed, which is that we need to encourage more podiatrists to come to California. We need to encourage more college students to want to become podiatrists and need to make this profession more desirable and remove any barriers that look like they're treating them as lesser thans. And this would be something that I think would help in that process and is absolutely a concern to the public because the public's getting older. Your patient population is growing at a pace much more rapid than the profession of podiatry. And so we need to encourage that, and this will help. So we would support this going into the sunset measure and hope you would as well. Thank you.
Thank you, Mr. Spencer. During your research and discussion with CPMA and finding this as an ancillary item for DPMs stated in R3 versus R1, have you seen this more as a California issue or as a federal issue?
I can only speak to California because that's the only evidence that I saw. I mean, I do know that the glut of podiatrists is a national problem, not just a California problem. I mean, if it involves Medicare is obviously operated by CMS, and so I'm sure it impacts other professions, other states as well. The evidence I've seen directly would show different fee schedules that been applied to an individual who actually lives in the Sacramento area, had they works in an orthopedic group. The fellow MDs had 100% of the fee schedule, and he was listed as 80% of the same service. And so the evidence I saw was with commercial payers, not necessarily directly related to Medicare, even though the Medicare fee schedule is what they utilized. So I can't answer your question directly, but I'm assuming that is a national issue.
Mr. Glazer, Dr. Glazer?
But it does sound like there's things we can do here in California to help the healthcare of Californians.
100%. Yeah. And in some, we all know in some states, they do authorize DPMs to refer themselves as physicians. In California, you are not legally allowed to do that. That is all. Thank you.
Thank you.
Brian, if we describe specific terms for this motion, I'm trying to come up with the right terms for this. Are we using the actual ancillary status as a term for the motion that we need, or is there any other term that qualifies this?
That I'm not aware of. I think it would be ancillary. Would that be right?
May I propose a motion and then we could be discussed about, yes?
Yeah, Dr. McAloon.
I'll
Yes.
be happy to. The potential wording for our sunset bill could be that it is the policy of California that doctors of podiatric medicine shall not be classified or treated as ancillary providers in any healthcare setting or insurance reimbursement structure for any purpose. Sure enough. I'm sorry, it is the policy of California that doctors of podiatric medicine shall not be classified or treated as ancillary providers in any healthcare setting or insurance reimbursement structure for any purpose. This is, for comment, this is based on similar language that the DOs have.
Dr. Glazer. And then
I-
Dr. Patel.
Excellent wordsmithing. I don't know if I can add to that from a wordsmith level, but I think we need to add specifically not treated as an ancillary provider and paid indifferent to DO or MD or physician and surgeon. We can use either one of those as a word structure. My concern is that the entities may come up with a different category. And I want to make sure that is very clear that they're not allowed to do such things if we're going to proceed forward.
My suggestion is, and Brent, correct me if you would prefer not to be this way, is to just authorize staff to seek legislative changes to limit that and provide them like a little bit of flexibility there. I also would probably include some language like such as given the importance of being able to access adequate care, the shortage of DPMs and significant portions of California to lack access to care to kind of just like frame the board's missions. So it's a little different from what Dr. McLean suggested, but here's what I currently have. I move to authorize staff to seek legislative changes to not have DPMs classified or treated as ancillary providers in any healthcare setting or for insurance purposes, given the importance of being able to access adequate care for the public, the shortage of DPMs, and a significant portion of California that lacks access to adequate care. It's not the best, like, it's not the most tight, but do you guys feel like that kind of captures?
Instead of insurance, I would say health plans to be more global.
I would say health plan reimbursements, because health plan just means access to, right?
Correct.
And then do we need to add the word licensed DPMs in front of that? Or is there just assumption that?
I mean, essentially what the board is doing here is just authorizing. I guess the question is, you're authorizing staff to seek changes within the sunset report.
Okay.
Approving that, so.
And we'd be working with the committee staff
Yeah.
on this language.
Dr. McLuhan, are you okay with
I know
the
you,
proposed rephrase? Because you'll be making the first motion.
my little engines turning. Dr.
Yes,
Lee?
yes, I did. 'Cause
I'm really good at poker. This one, okay. Reimbursement purpose? Okay. Dr. Beautiful. So health. Perfect. I think that gives more clarity if that's specific. Okay. I am good with that. Thank
Would you like to pull it and read it off?
Certainly. Dr. Lee, may I make a motion?
Yes, please.
I move to authorize staff to seek legislative changes to not have DPMs classified or treated as ancillary providers in any healthcare setting or for health plan reimbursement purposes, given the importance of being able to given the importance of Californians being able to access adequate care, I'm sorry, I'm wordsmithing still.
Oh, go ahead, Brent.
Podiatric care, yeah, I'm gonna add, exactly. Thank you. I will read it all out again in just a moment as I just make these few word adjustments. Gentlemen, thank you for your patience with me. As I read it out loud, my doesn't flow as quite. Okay, let me try this again. Spelling would help. Okay. I'm going to try this again, please. I move to authorize staff to seek legislative changes to not have DPMs classified or treated as ancillary providers in any healthcare setting or for health plan reimbursement purposes, given the importance of Californians being able to access adequate podiatric care, the shortage of DPMs, and significant portions of California that lack access to this, to adequate care, adequate foot and ankle care. No, I'm sorry, adequate podiatric care. That's how it needs to be in this, should I do it one more time?
Yes, one more time, one more time.
I move to authorize staff to seek legislative changes to not have DPMs classified or treated as ancillary providers in any healthcare setting or for health plan reimbursement purposes, given the importance of Californians being able to access adequate podiatric care, the shortage of DPMs, and significant portions of California that lack access to adequate podiatric care.
Thank you, Dr. McAloon. Do we have a second?
Seconded.
Thank you, Dr.
Seconded,
Glazer.
Thank you.
Does that work for staff's needs as well?
We have a second.
Yeah, that's fine.
Brian, are you okay?
Yes.
Oh, is the language okay? And our legal counsel? You received it? Okay.
I second.
Okay, Dr. Patel second, Dr. Glazer second. I'd like to open it up for public comments.
I made the motion.
Dr. Glazer second too. Okay, thank you for the public comments. We'll take a vote. Kathleen, could you help us with the board vote?
Okay. Oh, I'm ready. Okay, I'm so sorry. I didn't hear that. Dr. Lee,
Accept.
Dr. Glazer,
Accept.
Dr. Patel,
Accept.
Dr. McAloon.
Accept.
Motion passes.
Thank you. All right, do we have any more items to discuss under section C?
I think is that it? Yeah, or are you going to do regulations?
That's it for that. And we'll go to regulations. It's just really an FYI as well. Pending is a section 100 to change a few of the regs under the requirement that we only have 3 things. We got rid of the continuing competence that is pending in the regulatory folder and also the disciplinary guidelines. So Brian and I and Bethany will be working on those this year after sunset and should hopefully present them to you soon. But that's just an FYI.
Great. Anything else from section C? Wonderful. I'd like to open it up to public comments. Any public comments before we close section C? Okay, thank you. Section D, public education. On behalf of Ms. Chang, Kathleen, could you help us
Yes.
present section D?
Section D is the public education report. And as I put in the first sentence of the paragraph under footnotes, we are going to publish this year. It's just, we're not trying to do it too early because sunset is going to have so much for us to report on that when that's done, maybe like in June or July this summer, we'll create the content. And if anybody would like to contribute anything that they think is valuable, a great idea on the Special Olympics, and anything else like that, please feel free to contact me or go through the mailbox, PMBC mailbox. And students, residents, anything that has to do with the DPM world in California is relevant. So just want to put that invite back out, and we should be closing this summer. Any questions on the newsletter? Footnotes 25. Okay, so social media, we are updating our social media websites and our PMBC website regularly. And if anybody has any comments or things that they see on there that they'd like to tell us to either update some information or change things. We're always looking for that. But I think the website is very well used. And I think mostly in licensing, we see all of our DPMs come through to see the website at least once every other year. So if there's anything else that someone would like to say about our social media world, we would welcome those comments as well.
Dr. Glazer.
And I don't think we're on Instagram. Is that true?
That's true. And not because we were given the choice and denied it. It was just DCA, we inherited Twitter and Facebook. But I can look into going to Instagram as well.
I have young children. That evidently is the way to communicate. So you're absolutely right. I was also informed of that too.
On Instagram, so.
I will get off MySpace then. Thank you.
How about the Facebook?
Yeah. So would we like to look into, is that the suggestion we forward at the next meeting?
I mean, we're looking towards the future, so I think following along with Instagram and TikTok, if that is the future of social media communication, that's probably what we should be following, maybe pun intended in that statement.
So if we go on TikTok, excuse me.
You should have a Tic Tac before doing a TikTok.
We'll keep you posted to the committee, what needs to be done.
Dr. McAloon.
I'd like to suggest to the committee, perhaps in the American Podiatric Medical Association, I believe, is moving on to these other platforms. So that might be a resource to take a look. What are they on? What are they doing? What are they posting? Because also that might be content, possibly. To my colleague's point, it's the younger people who are on those social media more so than us older people. That's where they're getting their information from, even though we may not be there getting it, that's where they're looking for it. So I think that perhaps taking a peek at what the APMA is doing might be helpful. To give us some data on how we can, where should we be and what should be there
Thank you.
for the committee.
Because we're a public government agency, we probably need DCA approval for any of these accounts. So I'd like to ask council to comment on that, and Brian as well as our EO.
So I personally am not fully familiar with DCA's guidelines around social media, but that is something that I do agree that staff should check in with DCA leadership before adding in new accounts.
Right, exactly. So we'll have to check in with the media department of DCA and see if that's avenue that's available. I'll check with other boards too, see what they're utilizing.
Thank you.
Dr. Glazer.
In that same context, do we have a policy on personal social media displaying state information for board members? i.e., if I wanted to post something today about what a wonderful meeting we had to protect Californians, how would I go about that? And could I?
That is something I'm also not aware of, though you could also probably reach out to maybe board and bureau relations or Brian, do you know anyone else at DCA could check in with on?
I think board relations probably.
Yeah.
Dr. Glazer, I'm not sure about that question, if there's an actual policy on using your private phone to say, hey, the medium, whatever you want to post about the meeting. I haven't heard of that, so we could take a deep dive.
Okay.
Look at it.
Yeah,
Hands up, Dr. McAloon.
I was going to ask if the committee could look into that as those kind of issues as well. What
What is acceptable?
What is acceptable? What does DC already have as guidelines, if there are any, for us, the board to be aware of? If the committee could gather some of that information as well. And perhaps do that first, in case, don't want to spend too much time digging deeper if we find out, oh, we can't go on TikTok, that's DC, for example. So I propose that first we find out if there are any DCA guidelines for the different healthcare boards for social media, find that out first, and then then investigate further what we might be able to do and perhaps bring that back to the boards for our information and discussion.
Then can we table this to our next board meeting once we've done more research and getting approval regulations from DCA? And then create an action item?
Sure.
Thank you.
Thank you all so much.
Thanks.
That concludes my report.
Thank you. In that case, I'd like to open it up to public comments, please. Thank you. We'll move on to Section E, Executive Management, Update, Discussions, and Possible Actions. Our sunset review was just not too long ago, March 24, 25. And we've had several meetings before that in preparation, including a mock meeting as well, and which was well attended. And Dr. McAloon present at the 24th meeting. I'd like to publicly thank her for her time and effort and her expertise and professionalism in that matter. Any discussion or comments from our EO?
Yeah, I'd just like to say, all this prep, right, all the prep, months and months worth of prep and loss of sleep, especially the week before the hearing, right? It's kind of what's going to be asked. I think we got it done within 10 minutes. So I just want to say thank you to Dr. McAloon. She did a fantastic job. And so I'd like to punt it over to Dr. McAloon and then Dr. Glazer, because he was on it remotely. And Bethany was there too. So any input or any?
There are benefits for being over-prepared, isn't there? I could have done more charts last week, and as much as I studied up to get ready for that meeting. So I think that, so we were the fourth board to go before the committee. And so witnessing what the other boards were going through were set my expectations of what we might be going through when it was our turn up there. And I have to say that was not the case. I have to thank our staff of this board for being so well prepared and thorough in their sunset review that it only generated 6 issues for the board, for the joint Senate and Assembly. The background paper was so thorough that they had only a few questions that they generated. We had prepared responses to all of those, and they had very few questions for us about our sunset review going forward. And to, as Brian commented, we were up, and I don't think my seat or butts were in that seat for more than 10 minutes.
Yeah, I was surprised by the first question, right? The first question that was asked, does the DPM, can you refer somebody to physical therapy? I'm like,
That was, did you see me? I
was looking at you.
like,
You have this smirk on your face. I was
like,
that's
That's-
one of the questions.
The time.
so yes, I was surprised by that question. But it was, I was the stat, your sleepless nights paid off. We were, well prepared going in, which made, when we actually got to the hearing, very little, questions or concerns because, the report was so thorough, and your communications, with their, with the legislative staff were answering all their questions. And so, yes, I think that, it was much easier than we anticipated. And so I think that's a good thing. Dr. Glazer, I don't know what your experience, that's the first sunset review I've ever been to before. That was my first one, so I have nothing else to compare it to, but what did you think, Dr. Glazer?
Well, for one, even remotely, I did wear a tie and pants, just so everybody knows. But congratulations to everybody here. Fantastic job. When it's concise and definitive like that, you know that you've done a good job. Especially, it also shows what we as a board have done for California to protect Californians, deliver great podiatric care, and make it accessible. So congratulations to everybody here. Well done.
Yes, I think it, to your point, Dr. Glazer, I think it showed that the high regard in the legislation to which this board is seen. I think that's a nice, I think
So
that's,
seconded.
I think that is a reflection on the hard work of everyone, board members and staff, that we're held in such high regard on Capitol Hill, and that the quality of the work product that this board does, the whole team, members, board members and staff, is our reputation. I'm proud to be a member of this board.
And Bethany,
I didn't have to say a word, and I'm not mad about it.
Thank you, Bethany.
But she was ready.
I completely echo all that. It was amazing. Kudos, hats off to Dr. McAloon, Dr. Glazer. our staff, our EO for being present there, Samantha, and all the preparation that goes into it, weeks, possibly years in preparing all the documents. And thank you for the great teamwork. Appreciate it. I know it does happen every 4 or 5 years or so, and it's a big event for our agency. And getting through this event quite successfully and with well prepared manner, it's great. Speaks volumes. So thank you, everybody. I think we also had discussion during that time about additions to the training on DEI during the
Yes.
background.
Yeah, so that's item E, yeah. So we have the copy for approval. That was our October meeting. I think we had our DEI workshop.
Mhm.
And you guys made some adjustments to it. So hopefully you had a chance to take a look at it, but this is for board approval. And this is what Solid came up with. They amended the sections that you guys wanted to amend. So this is the one for approval. And I looked at it, everything looks good. Everything looks like it was added that needed to be added.
Dr. Lee, may I make a
Dr.
motion?
McAloon.
I'd like to make a motion that the board accept the update to our strategic plan that we worked together on during our October meeting with the facilitation by the Solid team. Period.
Do we have a second?
Seconded, Glazer.
Any public comments? Okay, thank you. Let's take a board vote. Kathleen, could you help us for a board vote on item 2 of section E?
Yes. Dr. Lee,
Accept.
Dr. Glazer,
Accept.
Dr. Patel,
Accept.
Dr. McAloon.
Accept.
Motion passes.
Thank you. Section E, number 3 is the discussion and possible actions for adding holding cases for discussion on admin manual.
Yeah, so, excuse me, there was an issue that came up. There was a vote that needed to be voted on by the board. And one of the board members wanted to hold it for discussion. Now, working with Brennan, we took a deep dive and there was no instructions in our administrative manual. How many votes does it take to hold a vote or a discussion, disciplinary action or discussion at the board? So what would Brennan, you want to chime in?
Yeah, good comment. Yeah, so basically, so the general practices for the board has been 2. That's very consistent across DCA boards, is to have 2 votes to hold a matter for discussion. But without it's not necessarily a legal requirement, it's more of like internal board policy. So we went with 2 votes is the requirement, but we think it's a good practice just to formalize this within the board's admin manual. I will say that this is just a proposal. You guys do only have 6 members to the board, so you guys could choose one. That would be a fair option. I kind of split the baby and said, if there's 1 vote and another no vote, that would basically trigger the 2 as well. So that was kind of the compromise that my initial idea was, but this is also, you guys can also make changes here. Also too, I will point out too that we're also putting in a 14-day guideline for responding to these proposed decisions too.
Dr. McAloon.
Yeah. This is a small board. And I think we should have the topic discussion, but I've been on the board for 6.5 years. And so I have some, seeing how we operate. And my opinion on with my term on the board, if one board, let's say I was president, I was once. If there was one member of our board who wanted to hold a case, I would want to have it brought before all of us. my opinion on this small board is that one person would be enough to hold a discussion in front of all of us, is my opinion. And was that currently, to your, and I think in the past we have, hasn't that happened before where one person said, let's hold this, and we had the discussion, if I
believe so.
remember
Is
correctly.
That's correct, Tom, Bethany.
I believe Dr. Zapp held a case once and we all discussed it.
Yeah.
So, my suggestion is that one board member asking to hold a case is sufficient for me.
Dr. Glazier and then Dr. Patel.
So in the other boards that you referenced to hold, how many members do they have on that board?
It ranges. So again, this is standard recommended policy across all DCA boards. One thing to note though is that there is a 100-day deadline to vote on a lot of these decisions. So if the board doesn't have a meeting scheduled within the 100 days and you guys do vote to hold it for discussion, we will then be required to schedule a meeting too. So there's something just to think about. But again, this is just a board policy. You guys can, if you think one is an appropriate number, we can go that way too.
Yeah, that leads into my question in terms of what would need to happen in between if there is a hold. And the second part of that is a hold different than a no.
So again, I did put some clarity into here that if we had a hold and a no, that would count as the same. That's how I treated it. We'd see. Let me double check higher.
Because that leaves it open for folks to have a hold as a routine so they can discuss these cases in a group. I worry that ends up being the default versus saying no.
So as of right now, the way the language I wrote says is for the purposes of determining whether a case will be held for discussion, votes to not adopt the decision or stipulated settlement agreement will be treated the same as votes to hold the case.
Okay, so it's the same.
Yeah, so that could be if we want to keep it that's fine. If we want to keep it as that, and so I think if we have that language in there and there was one no, that would probably treat it also too as holding for discussion.
All right, Dr. Glazier and then Dr. McAloon.
Do we know the frequency of which a hold or no occurs? I mean, percentage wise of cases?
Oh, I don't know. Like, do you know, Bethany?
I don't have the number, but it's very minimal. It's not very many that are held.
Yeah, it's all kind of board and member
It can
specific.
happen in a few years.
Right, all I could speak is to my 6.5 years of being on the board. It has not been a common or burdensome issue to date. Cannot predict the future, cannot predict the future, but just going the last 6.5 years, it was a rare board meeting where it happened.
I agree with that. In my years as well, I've only seen one time that we had a health discussion. So the yield rate is very low.
Based on that, I would agree with Dr. McAloon. Then this is quite a process to get here and be on this board, which we're all honored to do. And I think that creates a lot of filtering and shows the experience and time that we have in this profession to make good adjudicated decisions. And so if a concern comes forward from one, I think it should be investigated or looked at.
In that case, question for our legal counsel and EO, are we adding language to the admin manual to specify the number right now, or is this a discussion?
We both. So I guess the question is, so right now we have ambiguity within our policies about that. So it seems like from you guys that you guys were like one, so that's something good to know going forward. We could probably craft a motion and put it now, or if you guys prefer, I could also take your feedback and come back with updated language if you guys would like to review the specific language before it gets added.
I'll leave it up to the board members. Do we have any preference as to tabling this for the next board meeting, or agree with one board member to hold the case and move on with the language? But in addition to that, my question to Brian as well, is this part of the sunset or is just admin manual?
No, this is just our internal admin.
Internal, okay. Then in that case, I think we don't have too much argument against one vote. So Dr. Patel.
Yeah, I was just going to say that I think we all agree. It sounds like that one vote should be enough. I think the question is, do we need language in there in terms of what the next steps would be, what timeframes that we would need to meet and how we would meet?
So that is statutory required.
Okay.
So it is 100 days from an an ALJ's proposed decision. So
Does that meeting have to occur in person or can it be done
it would
virtually?
have to occur in person. So all Bagley Keene requirements would apply to that, but it would be a closed session to discuss it. But it would follow the Bagley Keene things we've done before. And I should say that if the board doesn't vote on it within 100 days, the ALJ's decision just becomes effective as a matter of law. So that would be the consequences
That would
of,
be the default if we didn't. do
not a
that.
default,
Oh,
but it would go into effect.
Understood.
Yeah.
Thank you. If we did not take action in that 100 days, then
Yes.
they gave us.
So I think
would
that's
hold.
also why like a lot of boards also like use two as it. So like the board can act instead of just letting the AHL's decision go into effect. It's even if like one member votes or has like a question or something, I think that's why two is generally used, just to ensure that there's significant controversy. But again, this is all internal board policy, so it's a decision up to you guys.
And do we need a quorum for that discussion?
Yes.
And considering the 100 days, I'm looking at our schedules and our calendars for our in-person meetings. They are approximately 100 days, correct? So we can apply it to a closed session in our general board meetings. Should that happen?
Yes.
Okay. Then I propose we stick with vote 1 for language in our admin manual.
Do you want to move to adjust the language I have to one vote now? Or do you want me to come back with finalized language?
What's our current language?
It's in your materials. So if you go, it's about a page. I think the changes we would need to make is
From 2 to 1.
yeah.
The
if
fourth
our vote
paragraph.
is passed, I would also eliminate the final paragraph then and not treat a no as a hold for discussion in that situation. So
For the adoption of a new language, do we need a quorum in person or can we do it online?
you would have to do it in person.
Then why don't we get the new language proposed and new statements and we vote on it
At
in
the
our
next
June
one.
meeting?
That sounds good. I will change it. So just to clarify, you guys want one vote to hold it for discussion. And are you guys okay? And then we won't treat no votes as holding for discussion. We'll just treat it as a no and reserve the hold for discussion for if someone wants to discuss it in person with the board.
Great.
Yes, I think that's the intent of our conversation today. So I just have a question. Are we not able to vote on this today if we wanted to?
You guys good? This is all just.
My only concern to the rest of us is what if we delay in voting to approve this and something comes up between now and June, then we don't have the ability to use it. Then if there's any benefit in delaying, then of course, I propose that we do. However, if we don't see any benefit in waiting till June, why would we?
I didn't see any urgency just because our yield rate is so low
Mhm.
for the no and hold votes on cases. That was the only reason, unless anyone thinks otherwise. We haven't had too many closed sessions, discussions on one vote and one case, so unless we had a high number of holding cases to discuss on a regular basis, we just haven't. So historically, we've been very low.
Could we still treat it the same though, since it is ambiguous right now, that we could follow that same guidelines that we would, if we had a no vote between now or hold vote between now and June, we would
Yeah.
open it up for
Okay.
discussion, in a closed discussion, and then bring the language back to June.
Yeah.
Cool. Sounds good.
Okay, cool. We'll update the language and you guys invite it to the June meeting.
Thank
Okay,
you.
then for the record, our legal counsel will update us with the language on attachment A for admin manual to discuss at the June meeting. Everybody okay with that?
Thank you.
All right, thank you so much for the discussion. Does that conclude section E?
Yes.
Okay, I'd like to open it up for public comment on section E, 1 through 3. Thank you for the public comment. Do we need to take a vote? Yes, for section E before we close it. Kathleen, could you help us with the board vote?
Motion to, if we
Public comment and vote.
comment, do we have to do motion for all executive officer reports to accept them? Okay,
Yeah, we can do that and take a motion for accepting all sections A through E, and we'll take a board vote for acceptance. Do we have a motion to accept our executive officers report, section A through E?
Yeah, I'll make the motion.
Dr.
Glazer will
Patel.
second it. Thank
Dr.
you.
Glazer, second. Any discussion? Any public comments? Thank you. We'll be taking a board vote.
Dr. Lee,
Accept.
Dr. Glazer,
Accept.
Dr. Patel,
Accept.
Dr. McAloon.
Accept.
Motion passes.
Thank you.
Glazer.
Dr. Glazer. That concludes section 6. Moving on to future agenda items, section 7. Do we have any future agenda items? Dr. Glazer.
Discussion of transverse tibial bone transport. Sure, that's a tough one. Transverse tibial bone transport. Thank you.
Yes, Dr. McAloon.
I have something that I'd like the board to consider in the future. Doesn't necessarily have to be at the June meeting, but just something, as I will be exiting this is my final board meeting. And so I just.
I was about to announce that.
Oh, thank you. So this is not necessarily an urgent matter. It's just a matter looking down the road that I'd like this board to keep in mind. So how it falls in and what agenda, what meeting is not the important part to my mind. So we just had we had our sunset, we're in the sunset review process. It's not completed. We have a fee increase in that budget, which is not a small increase in the licensing fees. Podiatrist here in California, it's between a 40 and 50% increase from our current. And the number of podiatrists in California is currently pretty stable, pretty stationary. We are not
2237.
we're not currently a growing profession in the state of California. So the amount of licensees has been stable, yet our expenses, which are not most of them are not under our control, are continuing to rise. I think that we have to consider there is a point if nothing changes, if our numbers stay the same and the same financial burdens continue to increase, I think one can't help but predict that there will be a number at which this board, with the number of licensees that we have, that the financial burden on the licensees would get to a number that is not stable to the profession. Like if we just see where the numbers are going, our costs are going up for this board, our numbers are not. And so we just had this license, we're in the process of getting a license fee increase. And then to get us ideally 4 or 5 years through with that one, if we come and the board comes again in another sunset review and we're at the same impasse, I think we need to think what's the number? 2,000, 2,500, 3,000, at what number so I think we have to engage with our stakeholders about the value of being an independent board versus how expensive that will be, what our options will be in the future when that happens. And so that with the reality of the numbers of licensees we have and expenses it takes to be an independent board, where is that space And so not necessarily an agenda item on the next, but that's something that I'd like to ask this board in their ongoing years together to be mindful of and talk with the stakeholders, because if nothing changes, I think that there may be a point where that decision would have to be made, if we can afford to be an independent board, if we're on the same course as we are currently been on.
Dr.
Thank
Glazer,
you.
thank you.
Yeah, it's a very, very sage advice. I think what we've done here today and discuss what came out of our sunset meeting.
Oh, sorry, Member Glazer one. We can't discuss items right now. This is just for future agenda items.
I was going to comment. Hold my comment for next time. Thank you.
Sorry about that.
Thank you for the reminder.
You've been flagged like twice.
Sorry, I'm fun outside of-
There's no lack of passion, right?
There
Um,
is zero lack of passion.
Any other items for our future agenda? Everything well said, Dr. McAloon. If we don't have any, really, we would like to thank Dr. Carolyn McAloon for her years of service in public health. And beyond that, APMA, CPMA, ACFAS, in every avenue, you've been quite successful, helping tirelessly. And I don't know how you find the time and keeping up with the practice. I have met two of your mentor students who became DPMs, two, and they speak highly of you. And they became DPM because of you, So, and back then I didn't know you, and we were on the board together. So it's really an honor to share this space with you, with the government agency and public service. Terming out sadly, but I'm sure you have more adventures and public service that you'll do on your own, and with your practice and your family. Appreciate your 2 terms as president. I learned a lot from you the years and through our conversations and sharing committees and our board meetings. So it is my honor as the current standing president to thank you for your years of service for our agency. Thank you so much. We wish you the best. Stay in touch, protect our public, and encourage more people to go into this wonderful profession of podiatric medicine and surgery. Thank you very much.
Thank you very much for your kind words. It is, I thank you. I've been happy to serve, and I'm happy to leave with such great leaders in place that I'm not going to be you never want to be in a place where when you leave, you're going to say, how can they do this without me? That's not how you want to leave a position of leadership. You want to leave with, you have great leadership. You guys are all committed to serving the citizens of California. So that part I leave with no worries, no concerns. I will sleep well. It has been a privilege to serve. This is a very meaningful work, and I'm happy to do it. And thank you for your other kind words too, Dr. Lee, because I think as one of our duties is to make sure that those behind us, we're all passionate about podiatry, and I don't think I'll be able to help myself if I cease to. So maybe not in an official capacity, but I will tout the wonders of being a podiatrist in California for all our patients and for all our licensees. And thank you for the staff for all your years of support and helping the board do its work. You are also committed to podiatry and protecting California. And so we're grateful to have you as our allies and advocates telling everybody how awesome podiatrists are. Thank you for keeping up the, thank you all very much. It's been great.
I just want to make sure I can comment on that.
For clarity, it's future agenda items and minor administrative items.
Good and farewell is okay, though. I also, I've had the pleasure of following Dr. McAloon in many forms of public service. She's always left big shoes to fill, but she's always left them warm and ready to go. So we appreciate all that.
But no tinea.
No tinea.
Carolyn, I just want to thank you for your amazing leadership. You know, new to the board and coming in with you and being such a great example of a board member has been really a pleasure for me. I don't know if you remember, we, back in the CCBM days, we were, I think, 1 year apart, and your passion is still the same. You never changed. So I really want to thank you for that. Your passion for the profession has been incredible.
Thank you very much.
Yeah, Carolyn, thank you. I mean, two-time president, you got to testify in front of the legislature. What more can your resume fill in this state service?
Too bad I don't need a job.
So I just want to say thank you.
Thank you very much. I've been, you've made the job easy for me, Brian. You've been so well prepared and everything. You've done all the work behind the scenes to prop me up. And so I just had to, be the pretty face to get it across, but you were the man behind the woman getting it all done. So thank you for all that. You made the job fun and easy. And I appreciate all that. And what saw my colleagues here. I know that we take podiatry very seriously, and we're committed to advancing the profession and protecting the public. And we want to make sure that all voices are heard, all opinions are discussed. We're hear what everyone has to say and thoughtfully come to a consensus. We have had very little issues that were not found the right answer with good discussion. So I know we take what we do very seriously, but try not to take myself too seriously so that we can get the job done. I think it's been very enjoyable. It's been proud of the work we've done, proud to be together, working together, and thank you.
Unless we have any more items for future agenda, I would like to adjourn this meeting with the final words of our past president, Dr. McAloon. So I'll call this meeting adjourned.
Thank you. Do you have this? Okay, you have one of those. Okay.
We'll miss you.
Thank you. Thank you.
I mean, I've listened to